Hi, good afternoon, everyone, and welcome to today's session. I am Avisha, and I am the marketing lead at Consentin by Leegality. And we're here with AHPI today to talk about the impact of DPDP on the healthcare industry and the way forward. We're privileged to be joined by two distinguished leaders who have played a significant role in shaping quality patient safety and healthcare delivery in India. Dr. Girdhar Gyani and Dr. Sunil Khetrapal. Dr. Girdhan Gyani, Director General of the Association of Healthcare Providers in India, widely regarded as one of the pioneers of healthcare quality in India. He has previously served as Secretary General of the Quality Council of India and was instrumental in establishing NABH, India's National Healthcare Accreditation Framework. His contributions have helped place patient safety and quality at the heart of healthcare delivery across the country. Joining him is Dr. Sunil Kumar Khetrapal, Deputy Director General of AHPI. With nearly 4 decades of experience in healthcare administration and policy advocacy, he has held several leadership roles, including COO of Rajiv Gandhi Cancer Institute. He is a respected healthcare administrator, assessor, educator, and a speaker who continues to strengthen India's healthcare ecosystem. Please join me in extending a very warm welcome to Dr. Girdhar Gyani and Dr. Sunil Kumar Khetrapal. We are really excited to have this session with you, so thank you. Over to you.
Yeah, Dr. Gyani, sir, I think.
Okay, thank you very much. I actually want to convey my thanks to Leegality for coming forward and, sensitizing our members for this important regulation, which is going to be, I think it has already been published widely, and as being mentioned here in the first slide, that before May 27, what all we need to do. In fact, I am also told that November is another deadline, November of this month, this year, by which systems have to be defined and certain things have to be done, and which actually we will come to know through this webinar. In fact, only yesterday, myself and Dr. Khetrapal went to Ministry of IT to have a word with the head of the cyber law person. And in fact, we learned quite a few things from him. And as I could see that though the law or the regulation is going to be applied across all the sectors, but healthcare, I think, is going to be affected in the most significant manner. Because here we have data, enormous data, you can say. For example, I can't see, for example, automobile industry, where is the data? Very limited data is going to flow from the one work line from starting to the end. But in case of healthcare, I think, right, starting from the registration of the patient at the registration desk, then going through the complete cycle of the treatment plan, what we call it, and then the data going through the insurance company, and then we also engage a lot of vendors, good number of vendors into our system. So all in all, huge data is there, and the breach of the data or the breach of leakage of the data can be disastrous. And that is why I think our healthcare providers have to take this particular regulation in a very, very serious mode. And I'm very happy that Leegality is Leegality is already our member, I'm told, and they will be educating our members on this particular regulation. And all the best to all of you who are attending this webinar. Thank you very much.
Thank you, sir. So thank you, Dr. Gyani, for your opening remarks, and your words of wisdom. I think this is a topic which is very close to my heart and very important for the medical professionals, especially DPDP in healthcare. Today's webinar's topic is DPDP in healthcare, what every hospital needs to do, and which is organized by Consentin by Leegality. And AHPI has joined hands with them so that we can convey the message, the importance of DPDP Act and its implications in healthcare to all our member hospitals. The Digital Data Protection Act, DPDP Act 2023, in fact, it marks a very significant milestone in India's data governance journey for healthcare organizations, where we see that their patient data, which are very sensitive, the sensitive patient information, which is collected and processed, then shared and stored across multiple touch points, as mentioned by Dr. Gyani also, that we have enormous data in healthcare. So understanding and implementing the requirements of the DPDP framework is not merely a compliance exercise. So to me, it is a fundamental to maintaining the patient trust and safeguarding the privacy. Now, today's session it aims to provide practical insights into what every hospital needs to do for DPDP compliance, understand the flow of patient data within their organization, and design the effective consent mechanisms and strengthen their data governance practices. So we are privileged to have with us Ms. Amala Maria, who is a General Counsel Leegality from Mumbai. And Amala is a privacy and compliance lawyer with 7+ years of experience. And at Leegality, she works with large enterprise to make customer onboarding, document signing, and consent collection legally sound and audit ready. She holds a CIPP E certification in data privacy, and her day-to-day involves bridging the gap between what regulators expect and what actually works for business teams. So thank you all for joining us, and we'll look forward to an engaging and informative session. So I hand over to our speaker, Amala Maria, who is the General Counsel with Leegality. Over to you, Amala.
Thank you, Sunil sir. Good afternoon, everyone. First of all, thank you to AHPI for organizing this and giving us this platform. And thanks to all of you attendees for attending this on a Tuesday afternoon. We really appreciate it. I'm Amala, the host for today, and I head the legal team, and I'm a privacy counsel. In my work at Leegality, I have advised and worked closely with institutions on digitizing their paperwork, and I work closely on translating regulatory requirements into product and process implementations. And now with Consentin, we are also working on some of the biggest implementations of DPDPA, such as Union Bank, Coca-Cola, and are in POC discussions with hospitals like Wockhardt and the Hinduja Group. We are here to talk about the Digital Personal Data Protection Act, or the DPDP Act, and specifically what it means for hospitals and the broader healthcare industry, and what you actually need to do before the timeline of May 13th, 2027. And I want to use today's session to make sure that you leave with a clear picture of what that means in practice and not just in theory. So here's how we'll spend the next 40 minutes. We'll start with the basics of the DPDP, who it applies to, what it requires, and what is at stake if you don't comply. Then we'll go down deep into the areas that are most operationally complex for hospitals specifically, that is consent management, data principal rights management, group company data flows, third-party data flows, and data visibility and governance. And we'll also try to take up some queries. We'll close with a moderated question and answer session. I also encourage you all to put any queries that you have throughout this presentation in the chat box. It will help us pick up these questions and address them in the end or throughout the presentation. We'll also run some interactive polls to understand where you are in your stage at DPDP compliance and how it is that your organizations are looking at DPDP. So yes, that is our agenda for today. Basically, we don't want to give you a legal lecture. The goal is to help you walk out of this room or log off this call with a clear sense of what you actually need to build. I want to start with the poll to understand where you are in your DPDP compliance journeys. The poll will come up on your screen and you can put in your answers in the poll. We'll wait for some time for everybody to put in their responses and we'll close it in another 10 seconds. I hope everybody has put in their responses. Can we see the poll responses?
Yes.
So we have a very interesting poll result here. Many of you have not really started with implementation, still trying to understand the law. Many, 48%, which is the highest number, is discussing and planning it internally. That means you're at the whiteboard stage, you're planning and drawing out your agenda for how to do it. Started implementing, a very minor 8%, and nobody is DPDP compliant, of course. So with that, this is our agenda for today, right? We don't want you to still be at the understanding and planning stage, at the whiteboard stage. We want to ensure that organizations are ready to actually implement the DPDP and actually meet with the timelines, right? So everything I say today is going to be oriented towards the right side of the screen. That's the actual live working implementation, not plans, not intention, but what it looks like when it's actually done. So let's get into it. Let's start with the basics, right? Before I talk about the DPDP Act, I want to briefly also touch upon the frameworks that govern patient data privacy requirements today, right? It's not a complete vacuum. There are some regulations which already exist, some requirements, such as under the Ayushman Bharat Digital Mission, you are already required to take explicit consent before creating an ABHA account. Your HIS and EMR systems are supposed to gate record linking and cross-institution sharing on patient consent. That is also already in the ABDM framework. So the NABH Digital Health Standards, which came out in 2023, require a digital consent management system for any hospital seeking accreditation and the excellence rating. Please do let us know if the problem persists, but we have experienced that this usually resolves in time. So yeah, the NABH digital standards require that the consent management system is required in hospitals which seek to achieve the excellence rating, and the consent management system is required to capture and enforce patient privacy policies, and there must be a mechanism for patients to request correction, updation, and erasure of their data. The Indian Medical Council regulations of 2002 also impose general patient confidentiality obligations, rules on medical record maintenance, and there are specific consent requirements. For example, when sharing information for a clinical drug trial or reporting to public authorities, there's a consent requirement which is already there. Are patient record retention timelines under various laws which medical practitioners are required to comply with, such as 3 years under the Code of Medical Ethics, 5 years under the Medical Termination of Pregnancies Act, 5 years under the NABH accreditation standards, and for clinical trials, of course, there's 15 years data retention timeline. So why am I telling you all of this before we start with the DPDPA? Because the DPDP Act does not replace any of this. It adds to it. And in some areas, it is significantly more demanding. You cannot assume that because you are NABH accredited or ABDM compliant, you are DPDP compliant, right? It's a much larger requirement under the DPDPA. And yeah. So before DPDP, the slide captures the fundamental shift that the DPDP Act creates, right? Before the Act, personal data was, let's be honest, collected somewhat randomly, used for whatever purpose that was convenient, and shared with third parties without a great deal of formality. That's just how data practices evolved in most industries in India, right? With the DPDP Act, however, personal data becomes a trackable unit. It has a defined owner, that is your patient. It can be moved, transferred, shared, it can be returned, erased, deleted, it can be updated, it can be withdrawn. And at every step of that life cycle, your hospital, as a data fiduciary, is responsible for it. That word, data fiduciary, is important. We will next be looking at some key roles under the DPDPA. Right. So the DPDP Act introduces roles, and it is very important to understand who is what. Data principals are your patients, but they could mainly their patients, right? But they could also be your employees, your vendors, anyone whose personal data you process, right? This might be visitors who visit your hospital. They're the right holders in this framework. Data fiduciaries is the second type of character. They are organizations like hospitals, entities that basically determine the purpose and means for processing personal data. You, as a hospital, are the data fiduciary for your patient's data. That means you carry the primary compliance obligation. Now, along with data fiduciaries, there is a concept of significant data fiduciaries also, which is introduced under the Data Protection Act. Basically, significant data fiduciaries, they will be notified. The government has not yet given clarity on who exactly will be seen as an SDF. It might be hospitals, it might be big tech organizations, social media organizations, which process a lot of data. So that's notification is yet to come. However, significant data fiduciaries, once notified, will have more obligations than data fiduciaries, such as conducting data privacy impact assessments also. For now, since it's not notified, we can keep that aside. The next important character to understand is data processors. These are your vendors, the companies you engage to process data on your behalf. Your HIS vendor, your CRM, your HR management system, your cloud service provider. These companies or these entities process data under your instruction and on behalf of you. So they are data processors. Then there's the Data Protection Board, that's the regulator, which has investigative and adjudicatory powers and the authority to impose significant penalties on entities which are not complying with the Data Protection Act provisions. Then there's the Registered Consent Manager, which is a category of entity defined in the rules that can act as an intermediary for consent. It will sort of act as the UPI for consent, and it will act in the interest of the data principle for managing consent. As of today, none of the companies, nobody has been registered as a registered consent manager since the Data Protection Board is not functional yet. The ecosystem is still forming. However, the ecosystem today already has DPDP compliance platforms like Consentin, which help the data fiduciary in end-to-end data privacy and governance compliance to manage consent collection, withdrawal, retention, deletion, data discovery, data mapping, and breach management. Right? So these are basically the obligations that data fiduciaries have, and we will take a look at it in this slide, right? So what exactly do you need to have in place by May 13th, 2027, which is the timeline for data fiduciaries to get fully compliant with the Data Protection Act? This is the timeline for all data fiduciaries. The November timeline is for other entities like registered consent managers. Right. So basically the timeline that you as hospitals and data fiduciaries are looking at is May 13th, 2027, less than a year to go. Consent management, that is collecting consent, issuing notices and maintaining consent records is one of the obligations. Data principal rights need to be ensured. Patients have the right to access their data, withdraw consent, request erasure. You have to give them rights to nominate someone to act on their behalf and raise grievances if required. Now you need mechanisms to honor all of these data principal rights. And we'll get into each of these concepts in detail. Minor and persons with disabilities also need to provide consent, and this consent is through a parent or a guardian, right? So special rules apply here, which we'll come to shortly. Data retention, you need to know how long a type of data will be stored, and you need to have defined retention policies, and those policies need to be enforced technically, not just documented. Data mapping and ROPA, that's records of processing activities, need to be maintained. This is to ensure that you have visibility into what data you hold, where it lives, why you have it, and who has access. Third-party risk. Your vendors are your responsibility. You are liable for them. If they misuse patient data or any personal data, you are exposed and liable to the penalty or any other action that the Data Protection Board might want to take. Breach notifications. If there is a data breach, you must be able to notify both the data principal and the Data Protection Board in the event of a breach. There are timelines for this. And beyond this, there are other obligations also, but also other acts and regulations that you already have under the medical industry that also needs to be complied with, right? But with respect to DPDP, May 13, 2027 is your date, and all these obligations need to be ensured by that time. Now, the most talked about consequence of DPDP is the penalty, right? Up to 250 crores. This figure you all might have heard. But the real risk is below the waterline. Business disruption. If the board investigates you, your data operations can be disrupted. There can be reputational damage. A healthcare data breach or a compliance failure becomes a patient trust failure. There's loss of trust, which happens. In a sector where patients share the most sensitive information about their lives and bodies, this is serious. So the 250 crore penalty is real, but the consequences are much more, right? In the next slide, now we'll discuss how the DPDP Act actually impacts the healthcare industry practically. We've understood some of the basic concepts, but let's take a look at what exactly does it constitute for hospitals. The first thing is to understand the sheer volume of personal data that flows through a hospital. You are collecting identity data, name, date of birth, gender, phone number, email, Aadhaar, PAN, Aadhaar. You're collecting health data, diagnosis, medical history, lab reports. This is among the most sensitive categories of personal data that exists. Then you're processing trial and professional data, subject IDs for clinical research, doctor registration details. You're handling financial data for bank details, insurance information, payment details. Each of these categories is personal data under the DPDP Act. And importantly, the DPDP Act does not distinguish between categories of sensitivity in the way some global frameworks do. What changes is the context and the purpose of processing, and whether you have a legal basis to process with consent or for a legitimate use. Now, whose personal data is being processed? For hospitals, you are processing data of your end customers, your patients, your suppliers, your employees, your visitors, and you are running marketing functions. The reason I show this table is because organizations sometimes fall into the trap of thinking DPDP only applies to patient data. It doesn't. Your employee data is also in scope. Your visitor management system also captures personal data. Your marketing function, referral systems, they are also collecting and processing phone numbers and email addresses. All of that requires a legal basis. Either you should have consent or a legitimate use, and we'll come to that. All of it must be managed under the Act. I also want to touch upon the data collection landscape for businesses in the healthcare system to give you an idea of what data flows need to be worked on and what systems need to be mapped. For hospitals, the primary use cases are patient data collection and consent through enrollment forms, hospital registration, helpline forms stored in your patient CRM, and HIS or EMR systems. Your insurance claim processing through registration, insurance desks, claim forms stored in your billing system, TPA portal, and the insurer systems. For pharmaceutical companies, the focus is on clinical trials and research with consent collected through informed consent forms and electronic data capture. For diagnostics, it's consent for patient sample collection, report delivery through walk-in registration, home collection apps, or online booking portals. Then there are functions which are common across all these healthcare entities, right? HR and employee data, marketing and outreach through CRM, email tools, vendor onboarding through KYC, and other procurement tools. The reason this mapping matters is simple. You cannot comply with the DPDP if you don't know where your data is. This is the starting point. Before you can build a consent system, before you can honor a data deletion request, before you can map all your third-party vendors, you have to know your own data landscape and where data resides, what your data flows are. With this brief understanding of where and what kind of data your organization might hold, let's look at the obligations under the DPDP once again. 1. A consent collection system. Granular, specific, and unambiguous consent for each purpose is required under the DPDP. Second, a withdrawal and retention system. The ability for patients to revoke consent, the ability to enforce retention and deletion policies. Third, a third-party risk system is required to maintain oversight of all your third-party vendors and data processors. Fourth, you need to have data visibility and control. That is, you need to have full visibility of your data, what data you have, where it lives, who has access to that data, in which systems is that data present. 5, you need to have a breach notification systems. If there is a breach at any point in time, you need to have the ability to not only detect and assess the breach notification, but you also now have the obligation to notify the board and affected individuals when a breach occurs. Now, none of these requirements are optional. They are the minimum infrastructure the law expects you to have in place. We will quickly run a poll here on what is the biggest challenge and concern that you think your organization faces at this point. The poll is available. It should have popped up on your screen. Please do vote in, and we'll discuss these results. Basically, building each of these systems from scratch and making them talk to each other is a requirement. But this is precisely also why most organizations end up behind on compliance timelines. Therefore, it's worth evaluating tools like Consentin, which are purpose-built to give you all 5 of these as a single integrated platform: consent collection, preference management, data principal rights, ROPAs, data mapping, discovery, and breach notifications. Right? So this is where these third-party tools will help you in ensuring compliance, because these requirements are quite onerous. We have closed the poll and we are looking at the results. So honoring patient rights, that's data principal rights management, is a big concern with 21% people voting for it. Main concern, as you all have rightly identified, is actually third-party and vendor risks, because every organization today is using multiple third-party vendors. Another issue is definitely knowing where all your data lives. And this is why a data discovery process is required, and you need to map out your data. Managing legacy data is again one concern that people have voted in for. Thank you for voting in. So we can now take a look at some of these obligations and how you need to address these in your systems and processes. Under the DPDP Act, you can process data only under one of two legal bases. So one is consent, and the second is something called legitimate use. Under Section 7 of the DPDP Act, there is a category called legitimate use, where a hospital can process data without consent. So these include, and these are very narrowly defined, these include medical emergencies, natural disasters or epidemics, employment-related processing. So if a patient arrives unconscious and you need to access their records to treat them, that's a medical emergency, and you don't need to wait for the patient to first give consent to process their data. The second branch is something that covers data of children processed by clinical and mental health establishments and allied healthcare professionals to the extent necessary for the protection of the child's health. Again, this is a very narrow exemption. It is to the extent necessary for the protection of the child's health. And if you're doing anything further with that data, that will still require consent. So again, consent is not required, only to the extent necessary for the protection of the child's health. Now, everything else, any other situation where you are collecting or processing personal data, requires consent under the Data Protection Act. Now, here is a critical point I want every hospital administrator in this session to hear. The consent form that you already take at admission, or the one that your patient signs before surgery, is not data protection related consent. It's not DPDP consent. That form is medical consent for consultation, treatment, or procedures. It does not authorize you to process their personal data for medical record keeping, marketing, or to share it with an insurance partner, or to add them to any marketing or wellness program that you might have, or to create a hospital application account. Those are separate purposes. Each one requires its own consent notice, and the person has to consent to all of these purposes. Additionally, whether you process data under legitimate use, that is those exceptions that we already spoke about under medical emergencies or natural disasters, or whether you use consent to collect data, principals always have the right to access their data, update it, and request deletion. Rights exist independent of whether you took it under consent or under legitimate use. Now, next we move to a new requirement under the DPDP Act, that is consent requirements for minors. A verifiable consent of a parent or guardian is now a prerequisite for processing a child's data. Now, here's an important practical question that many hospitals ask. If a patient self-declares as an adult, do you have a legal obligation to verify that? The answer is no. The Act does not impose an obligation to verify the age of the data principal. But here's the flip side. The Act does not require that a parent's identity and age or status as an adult be verified. The Act does require that a parent's identity and age or status as an adult be verified. when they give consent on behalf of a child. So if a child presents at your OPD and a parent is giving consent for the processing of that child's data, you need to first verify the parent's identity and age through a reasonable process that establishes they are who they claim to be. So operationally, this means that your registration workflows need to capture the relationship between the patient and the person giving consent. And you need a mechanism to record and store that verification. For most hospitals, this is currently a gap. Since this requires a layer of verification and integration with your patient registration workflows, you can, for this case, look at solutions like Consentin, which will do the back-end work of getting the verification process in place in a scalable manner through DigiLocker and Aadhaar infrastructure, which we have already built for. Similarly, provisions apply to persons with disabilities and the same logic flows through. Under the DPDP, a person with disability, where they are unable to give consent themselves, can have a lawful guardian give consent on their behalf. The framework is similar to parental consent for children. What this means operationally is very similar to what I just spoke about. You need to only be able to identify at the point of data collection whether you are dealing with a situation where someone other than the data principal is providing consent. You need to capture who that person is, in what capacity they are acting, and you need a record of that. Now, healthcare is one of the sectors where this will come up most frequently. You will have patients who, due to cognitive conditions, physical disabilities, or other circumstances, cannot meaningfully engage with the consent notice required under the DPDP. Your systems, therefore, need to be able to handle that scenario, not just as a policy statement, but as an actual workflow in your registration process. So this is something that you all need to be very careful about. Now, we want to run another poll here before we move to the next slide. We want to quickly understand how data and consent currently flows in your organizations, right? So do you have paper forms at registration? Do you have a single checkbox on your application or website? The poll is on your screen. Please participate in the poll and we can look at the results. We'll also be dealing with these common consent flows in the next few slides. We'll wait for another 5 seconds and then we'll close the poll. So the poll, yeah, so many of you have said that you have paper forms at registration. This is, of course, the most common flow in hospitals in India. Then there's a single checkbox on your application or website. This again will not be a compliant DPDP flow, and we'll see how. Some have said that it's verbally but not formally recorded, and then there are other channels. Great. Thank you for participating. So now let's deal with the most common data flows in hospitals. A patient comes in for OPD registration. The receptionist asks for the name, phone number, date of birth, and Aadhaar number. And actually, a host of other personal data details may also be collected. The patient provides it, and the receptionist directly enters into the system. Then, in what might feel like a perfectly natural, friendly moment, the receptionist asks, "Would you like to sign up for our hospital's wellness programs and health tips?" If the question is being asked at all, right? In some cases, that is also not asked. And the next thing that happens is the patient has been added to the pharmacy partners mailing list. Their details have been shared with insurance TPA partners, signed up for WhatsApp alerts, promotional emails, and whatnot. And the patient quite reasonably is now wondering, wait, did I agree to all of that? The answer under DPDP is clearly that they did not consent to it, not in any meaningful or compliant way. This is the reality of current data collection in most hospitals. Data is collected at registration and then used freely for app account creation, ABHA account creation, marketing, billing, insurance, often without the patient understanding what they've agreed to. Now, the DPDP Act changes this fundamentally from May 2027. Every use of that data needs a lawful basis, and for most of these purposes, that is marketing, insurance sharing, referrals, data sharing with equipment manufacturers, the basis that you need is consent. Now we'll look at the digital equivalent of the same problem. A patient is booking an appointment on your hospital application. They search for a doctor, enter their details, name, phone, date of birth, and there's a checkbox at the bottom. Sign up for consultation reminders, wellness programs, and partner offers. They don't read it. They tick it because the firm won't let them proceed only without it. And then they start receiving promotional messages from you or your partners. Under the DPDP Act, the checkbox does not work as a consent mechanism for sharing data with third parties or for marketing, because the Act requires consent to be free, specific, informed, and unambiguous. A bundled checkbox, especially one that conditions service delivery on consent to marketing, is none of these things. You need explicit, purpose-specific consent for sharing with insurance partners, for marketing communications, for adding patients to any other wellness programs you may have, and you need it separately from the consent for core services. Now, this is what it should look like after DPDP. The patient comes in, the receptionist asks only for the minimum data that is needed to initiate registration: name and phone number. Just words needed to create that first record. The patient provides it. The system initiates registration by triggering a consent notice to the patient with meaningful and optional consents for each purpose, and without which the system does not store the registration details that have been given by the patient. Only once they give their consent choices does the registration and processing of data happen, and there is a record of the consent which is made and stored called the consent record or a consent artifact. For hospitals with mobile applications, and most of you either have one or are building one, your consent flow also needs to be updated there. DPDP compliance requires requests for data to be preceded or accompanied by a consent notice. Therefore, before the data goes into any of your systems, a consent notice has to appear. It lists each purpose with its own selection: consultation, medical records, AHPI account creation, offers communication. The patient selects what they consent to. The booking is confirmed only after that consent is captured. This is not a minor UX tweak, right? This is a redesign of your registration and booking flows. It requires product and engineering involvement, and it needs to be treated as a serious development project. Now, a lot of our journeys, as we already saw in the poll, in reality are phygital today, half paper, half digital, right? You first ask the patient to fill in a paper form, and then you digitize it on your system. Another question I get a lot from businesses is, what about patients who are not tech savvy? What about walk-ins who don't use any mobile application? How do we collect digital consent in a physical setting? This is a real challenge. And this is being grappled with not only in the healthcare industry, but also in the banking industry also. Now, there are several options to handle consent in physical or phygital settings. First, a branch tablet. The patient gives consent directly on a tablet at the registration desk. A consent notice is presented on screen. They read it and they accept or decline purposes by touching the screen and making their choices. Second, a physical form is given, which is scanned later. The patient fills a physical consent form, and that form is scanned and uploaded as a proof of consent on your compliance platform. This works, but it comes with some risk, which we'll address in the next slide. Third, in-person consent with IVR or SMS. Notice of the purposes and consent notice happens on IVR, or consent is captured via an SMS sent to the patient's phone. So there's a digitally verifiable record even for in-person interactions. Whatever method you use, the backend needs to integrate with your CRM or HIS, and the consent record needs to be uploaded to your compliance platform. Yeah, so now we move on to the physical forms for consent. Now, if you're relying on physical forms for consent, I want you to address these three specific risks, right? First, say with a vendor for digitization, all the PI on that form is being shared in plain text without tokenization or encryption. That's a data security issue that becomes a DPDP liability. If you're using OCR, there may be OCR errors, and that creates a legal, financial, and reputational risk. Third, there's a storage cost also involved. With or physical processes can be used, but they should be the exception, and this is not what we advise. This should not be the default. Now we move on to notice designing, right? So a consent notice is mandatory, as already we've seen under the law, and there are specific requirements under the Act. One, notice on the left, we'll take two kinds of notice design. One requires 5 to 7 clicks to complete. There are multiple expandable sections, checkboxes. It's overwhelming. And notice B is a clean notice. This notice is presented clearly, 2 rows, account opening, marketing. Each row shows the purpose and the data categories involved. There's a clear accept all, accept selected, or cancel option. And there's a link to manage consent and raise grievances. The consent is specific, and this is what the Act requires. You have to give them the option to withdraw their consent, the option to see it in another language. And this, while designing a compliant consent notice, you also need to optimize for the customer or patient experience. Ingredients of a DPDP consent notice, it's on your screen. You have to give them language choice. So vernacular languages, it has to be purpose specific consent, data categories for each purpose, each category of data also, name, phone number, Aadhaar, health data, all of that needs to be mentioned, and rights await for the patient to raise grievances or to raise a data principal rights request. So these are specific requirements under Section 5 of the Act, and you cannot do away with any of these. And you also have to ensure that the records of consent you collect are auditable. Now, why does an auditable consent record matter? Because tomorrow, if a patient disputes what they consented to, you need to have a record, a verifiable consent record that you can show the data protection board or authorities that you actually had proper consent. With that, we move on to one common concern that everybody has, that is one-time notice for legacy data. The Data Protection Act says that you have to give a notice to your existing customers whose data you already have. You have years of patient data, right? What do you do with that? Now, you don't need to collect fresh consent under the Data Protection Act. What you need to do is you have to give them a fresh consent notice with a meaningful way to raise data principal rights or to withdraw their consent if they want to. The notice is mandatory. And how do you actually, in practice, deliver this one-time notice to your entire patient base, right? For patients who use your hospital application, you can send in-app within the application notifications. This is lowest cost, highest reach for that group. For patients where you only have a mobile number or email, trigger an SMS or WhatsApp message. And for inactive patients, if you have a mobile number on record, send the notice as an SMS. This is a one-time notice and effort to actually give the notice. Next, we talk about consent withdrawal and data retention. This is one of the hardest problems. The next slide will tell you that there are 6 or 7 rights that the data principal has. Now, each of these rights require a technical mechanism to honor. You cannot actually comply with the right to erasure if you don't know where your data is and it is actually across 12 systems, right? So this is why data mapping is foundational. What you see in a data preference center, this is where data principals can actually manage their data rights. This is just a front end. How do you actually ensure that an action is triggered in the back end? The patient's preference needs to flow through to every system that holds data for that purpose. So here we've taken an example of deleting my email address from marketing systems. That's the right that the data principal has requested. How do you ensure it? You have to ensure that only from the correct systems the data is deleted. But where you have a requirement for data retention, that is in your EMR systems or your HIS systems, there, or with your third-party insurance, there that data needs to be retained and you cannot delete data from there. This is not a simple engineering problem, right? This is why I said that consent withdrawal is the hardest problem to solve. Now, how do you solve for this? The checklist here is a practical guide for what you need to build for a working and compliant DPDP compliant process. A preference center, define event policies for both retention and erasure, set regulatory retention timelines, and you have to know what your retention periods are. These must override deletion requests, right? Where the law requires you to retain some data, you have to retain that data for that period. Then you have to build callbacks to verify that deletion has actually happened in your downstream systems. You have to log the full deletion flow. You have to send a notification to the patient confirming that their deletion request has been processed. Right, so this is a checklist and you can refer to it. Next, we will talk about one very common problem, data flows between group companies. Many large hospital groups operate across multiple entities, a hospital's division, a diagnostics, a lab chain, a pharmacy chain, all under a parent company with subsidiaries. The question is, can you collect a single consent for all three? No. Under the DPDP Act, each legal entity is a separate data fiduciary and you have to have proper consent for all of it. So what doesn't work is sending a single consent notice. The patient's consent must be with the specific data fiduciary that is going to use the data. A blanket group level consent does not work. What works instead is a consent to transfer. Company X here in this slide, you will see the hospital collects data from the patient. In the consent notice it presents, it includes a specific purpose of transfer, sharing data with affiliated companies for the following services. It names them properly: diagnostics, pharmacy, and it specifies what data will be shared and for what purpose. The patient consents to that transfer specifically. And this means that the consent notice that X1, that is the hospital, presents needs to include these intergroup transfer purposes explicitly. And X2 and X3, the pharmaceutical company, cannot use that data for any purpose beyond what was described in X1's notice. Again, this is another way, a cleaner approach from a compliance perspective, how you will manage consent in group companies. Each of these entities takes specific consent for the data that it is collecting and processing, and each entity is responsible. But here, what happens is you cannot do referral or marketing with the data that you have collected for one entity with another. Right. So this approach on what you will actually use within your organizations and group companies varies, but the accountability and records cannot be skipped. Now, next, we look at third-party risk. This is the downstream vendors, another very important thing in the Data Protection Act. Let's look at the list, right? Insurance providers and TPAs, pharmaceutical companies. There are multiple third-party vendors that you use. The thing is, you are liable for all of these downstream third-party vendors. We wanted to run a poll to understand how many data third-party vendors you would have, but we are running short on time. We'll skip on that. Next, we will leave you with some practical tips on how to actually deal with data processors. One is always assume that you are the data fiduciary, even when you're not. Two, when you have you need to have 3 layers of controls for each of your data processors. Effectively managing third-party risk requires contractual, organizational, and programmatic controls. Contractual controls, you have to start by establishing a DPDP rule set, internal standards for what should be in your contracts. You have to audit your existing contracts against that rule set. And then you have to execute the amended contracts with your third-party vendors. Start with the high-risk vendors first, and then you move on to your lower-risk contractors. And finally, this is a step that most organizations miss. Your contracts must feed into your ROPA or records of processing. Now, next we deal with vendor risk contractually. If you just maintain a contract, that's not sufficient. What you need to actually maintain is that you need to have audits, right? We'll skip on a few slides, Avisha. We can come to organize slide 48. Alongside your contracts, you need an organizational framework for vendor risk. You have to have a third-party risk management framework to define how you assess onboard, monitor, and offboard data processors. You need to map all vendor relationships into your ROPA. And you need to have data privacy in existing InfoSec and risk audit processes. Most hospitals already do some form of vendor security audit. Step 4, when you onboard a new vendor, run a data privacy impact assessment before you grant them access to the personal data, right? So add them to your ROPA. Don't let new vendors start processing patient data before these are complete. Now we'll come to ROPA. I've spoken about ROPA a bit. ROPA is basically records of processing activities. This is a master inventory of every activity in your organization that involves personal data processing. Why is it important? You need to understand where your data actually lies to create a ROPA. And for that, we have a process called data discovery. Before you can build a ROPA, you need to do a data discovery exercise. You need to understand where your data actually lies, what your processes are. And this is technical work. It requires scanning your databases, reviewing your systems, interviewing your department heads. It takes time, and the compliance timeline, it actually suggests that it takes around 40 weeks sometimes for a large organization. So you need to really start now. In data discovery, you'll also understand that there are structured systems versus unstructured data systems. Your HIS or your LIMS, your HRMS, your CRM, these are the easy layers where you know that there is data, and these are structured databases. But unstructured data is where you have an employee device, an email inbox, shared drives, Google Drives, spreadsheets that someone exported once. So this is unstructured data, and you need to scan both the databases. This is very important to ensure that you know where data is lying and there are no leaks in the system, right? So next we have ROPA and how it actually looks in practice. On the back end, it's a structured database. And on the front end, it should be navigable, a dashboard where your DPO or legal team can see the full data map and understand the relationship between activities. Now, the ROPA is a constant activity. It's not a one-time activity. You have to keep updating it. And there are IT teams, legal and business teams, which need to work together to ensure that your ROPA is actually a living document. Now, rights mapped to operations is the next thing that I wanted to briefly touch upon. So we spoke about data discovery, ROPA. Why does this need to be done? And why are these DPDP obligations important? This summary ties it all together, right? This slide. All of your rights have specific actions that need to be done to ensure that you can actually provide for those rights. Each of these is a project on its own, but together they form the complete picture of what DPDP compliance looks like in operation. Now, we are almost towards the end of it, and then we'll have some question answers. I'm sorry, we're running short on time, but DPDP compliance basically requires a lot of time, and there is a 12-month action plan that we've laid down for you. In the next 30 days, form a multi-department DPDP pod. Someone from your legal, IT, product, clinical administration, and HR team needs to be a part of this pod. Map your data and systems at the high level. Inventorize your patient and user touchpoints. In the next 2 to 4 months, build your DPDP compliant consent notice. Log down your data safeguards and logging. Build your privacy center for data principal rights. Update your vendor and processor contracts to include DPDP obligations, and update your DPAs, MSAs, and other third-party agreements. Within the 12-month window, you need to also go live with your full consent technology stack. Integrate privacy into your organization wide compliance architecture so that DPDP is not a one-off project, but an ongoing operational reality that you need to comply with after the next 12-month window, right? So we come to the end of it. The journey to a DPDP-ready organization feels huge, very complicated when you look at it as a whole. But given our experience helping organizations get DPDP compliant, this is our one advice and one tip to you. You have to start with one business unit, say your OPD registration flow, and build DPDP compliance there first, end to end. Consent notice, preference center, deletion flow, vendor contracts, ROPA entry, get all of that right for that one business unit. Getting one end-to-end flow right makes it easier to scale to the rest of the organization and rest of the data flows, right? So start small, start now, and deliberate what you're building towards. I also just wanted to say that if the timeline looks daunting and if your organization is looking for a partner, organizations like Consentin, which has a DPDP compliance tool, also help you comply with your DPDP Act obligations within the timelines.
Thank you, Amala. Thank you, Avisha. And thank you, Yogesh, behind the scene. I think he was the one who has been chasing me for this webinar, and it has happened today. Thank you so much.
Thanks.
Bye.